Okay, this is Thad LeVar. I'm not sure when I pushed my mute button. So I'll start over. We are on the record in Utility Facility Review Board docket 20-35-3. This is the day 3 of the hearing on the merits. And let me go to parties at this point. Do we have attorneys for Rocky Mountain Power present?
Good morning. This is Brett Wright with Rocky Mountain Power.
And Heidi Gordon with Agent Bangkok, Rocky Mountain Power.
Okay, thank you. And Midway City?
Corbin Gordon and Joshua Jukes from Midway City.
Okay, thank you. And Valley-wide opposition to large transmission lines?
Yeah, good morning. This is Mark Morris. Liz Brereton and I are on this morning.
Okay, and what we've scheduled to do this morning is have closing statements from parties and then board deliberation. So let's move forward with closing statements. Let me just ask the parties, is there any objection to doing these in the order of Rocky Mountain Power, then Midway City, then Volts? Any concerns with that order? We'll move forward that way. Board members, I think we'll allow questions from the members of the board after each opening statement. However, if you feel like it would help to interrupt to ask a question, I don't see any reason why that isn't possible also, but we will stop in between each closing argument to see if we have questions from board members. And so we'll go first with Rocky Mountain Power's closing statement.
Thank you. This is Brett Reich with Rocky Mountain Power. The governor of Utah recently asked Rocky Mountain Power's president to attend a press conference to assure the citizens and businesses of Utah that the lights will stay on during the coronavirus pandemic. Rocky Mountain Power and Heber Power and Light provide an essential service to their customers. It is critical to the welfare, safety, and well-being of our entire community. This service is so essential, the Utah legislature created this board to protect the integrity of the electric transmission and delivery system. The integrity of the electric transmission system must be the paramount concern of this board and must govern the decision today. The first question this board must address is whether there is a need for this project. The record in this proceeding shows this project is absolutely necessary to retain the statutory reliability standards in the Heber Valley. Because there's an immediate need to protect the integrity of the electric transmission and delivery system in this state, then the board must ask whether the project has been impaired by a local government that would prevent these two utilities from providing service to its customers in a safe, reliable, adequate, or efficient manner under Section 54-14-201 of the Facility Review Act. The answer is yes. Rocky Mountain Power asked this board to protect the integrity of the electric transmission system by finding the overhead construction of this project must proceed forward immediately as authorized in the conditional use permit. This can be accomplished in several ways. First, Midway City failed to meet its self-imposed conditions under the conditional use permit. The permit requires Rocky Mountain Power to submit 3 actual competitive construction bids prepared by qualified, bonded, and insured third parties. Mr. Darren Myers testified that 3 bids meeting those requirements were provided to Midway City on March 27th of 2020. Those bids were submitted by reputable, well-known, and reliable contractors. Those contractors were Wasatch Electric, RES Group, and Summit Line Construction, who is located in Heber Valley. Although Midway City and Volts complained about the bid amounts, they never disputed receiving a copy of the bids as required in the conditional use permit. Nothing in the conditional use permit or the Facility Review Board Act requires Midway City agree with the bid amounts or approve the contractors. 3 bids were requested and 3 bids were received by Midway City. Under the conditional use permit, Midway City was required to select a route within 15 days of receiving the bid. It is undisputed that Midway City did not select a route, but instead objected to the bids and continued to delay this process, claiming the bids are too expensive. Rocky Mountain Power presented testimony through Mr. Myers that the bids were based on Rocky Mountain Power's standard specifications. the same specifications used for other projects. Specifically, Midway City questioned the use of spare conductor in the bids. Rocky Mountain Power testified that the use of spare conductors has been a standard specification since 2015, 5 years before these bids were obtained. This board should not ask Rocky Mountain Power to compromise its specifications at the request of a local government, especially when it is Rocky Mountain Power that will be maintaining, repairing, and operating the transmission system for several years to come. Rocky Mountain Power likewise testified that Rocky Mountain Power's standard specifications and the National Electric Safety Code require the circuits or the conductors for RMP and Heber Light and Power be placed in separate duct banks. Mr. Myers and Mr. Clegg testified that this is a standard RMP specification that serves the purpose of protecting the lines from third-party incidents, allowing two utility companies to safely work around and maintain the underground lines, and increases reliability. This board should not ask Rocky Mountain Power to compromise our standard specifications requiring separate duct banks for each utility in accordance with the NESC. Based on Midway City's failure to select the route and proceed as required in the conditional use permit, the board should find that Midway City has waived its rights under the conditional use permit to impose the alternate route of undergrounding the line, and Rocky Mountain Power is immediately authorized to proceed with the overhead construction as authorized in the conditional use permit. This decision would not require the board determine what constitutes actual excess costs, standard costs, or timing of payment under the Facility Review Board Act. An alternate method under the Facility Review Board Act, the board has several statutory provisions that authorize it to find Rocky Mountain Power can and should immediately move forward with the overhead construction of the project. None of these statutory provisions likewise require the board to determine standard costs, actual excess costs, or the time period to pay such costs. For example, Midway City's conditional use permit requires construction in a manner that will not permit RMP and HLMP to provide services to its customers in a safe, reliable, adequate, or efficient manner in violation of Section 5414-303 1C. And why not? Because there's no finality to the permit. It continues to delay the project and prevents the critical infrastructure from being installed to protect the utility customers in the Heber Valley. Because it asks the companies to continue to delay addressing statutorily required reliability standards and requirements. It asks the utility's customers to bear the risk of rolling blackouts or power outages or voltage reduction, especially during winter months when demand is high. RMP's Director of Transmission Planning testified there will be up to 620 hours of exposure to the risk of inadequate voltage to customers in the Heber Valley and Park City areas until the project is completed. The hours of risk will increase annually. Midway City's own expert testified there is a valid basis for completing the construction as soon as possible, and testified during cross-examination that the need has existed for years and should have been addressed a long time ago. Even Midway City recognizes the urgent need to address the potential exposure by stating in the conditional use permit that, quote, the proposed benefits neighboring areas and the entire power grid by providing more connectivity and redundancy to support better function of the system as a whole, close quote. What is the prejudice to Rocky Mountain Power, HL&P, and their customers if this project is not allowed to move forward immediately, or wait until a November bond vote, and if approved, funding in February 2021? The very real and tangible prejudice to RMP and HLMP and their customers is that they, not Midway City, are asked to bear the risk of blackouts, going without power, and the very real threat of a power outage or failure in Parleys or Provo Canyon caused by a wildfire, or the threat of wildfire caused by high winds and dry climate conditions, avalanche, or any number of events that could impact the reliability of the transmission system, especially during winter months when the demand is high. Delay in this project is not acceptable and compromises the safety, integrity, and reliability of RMP's transmission system. In another provision under the Facility Review Board Act, Midway City failed to act on the application within 60 days in violation of Section 5414-303-1E. RMP and RMP and Heber Light and Power submitted a joint application to Midway City on April 22nd of 2019. 8 months later, Midway City issued a conditional use permit on December 17th, 2020. The 60-day provision is identified in the statute for a reason. It means something. It means local governments are not allowed to delay critical electric infrastructure while the local government decides whether it has funds to impose excess costs on the project. Once again, the prejudice by continuing to delay this process is borne by the utility customers of this state. Midway City's conditional use permit purports to impose conditions in Wasatch County that are in direct conflict with Wasatch County's conditional use permit in violation of Section 5414-303-1F of the Act. Midway City's conditional use permit requires taking the underground line above ground and locating dip poles in Wasatch County. This is not authorized under the Wasatch County permit, and Wasatch County has not agreed to this condition. Midway City has no authority to impose conditions on Wasatch County any more than it has any right to impose conditions on Colorado or Alaska. Finally, the board has the authority and facts to support the finding that Midway City waived the right to impose actual excess costs. Under Section 5414-204, it states any requirement that imposes actual excess costs are waived if they are not paid within 30 days before the date construction of the facility should commence to avoid a significant risk of impairment of safe, reliable, and adequate service to its customers. The Act defines commencement of construction of a facility to include the project design and ordering of materials necessary to construct the facility. Midway City has not paid a cent toward actual excess costs, even assuming for sake of argument that actual excess costs are difficult to ascertain with exact certainty. Midway City would still be required to pay something to meet the statutory 30-day deadline in the statute. To find otherwise would require the utility to finance the actual excess costs imposed by the local government. This directly contradicts the intent and purpose of the Act. Because there's substantial evidence supporting the statutorily required significant risk of impairment of safe, reliable, and adequate service to customers, the 30-day payment period was triggered as soon as Midway City imposed any condition that imposes actual excess costs. No payment was or has been made within 30 days of December 17, 2020. In fact, Midway City refused to pay the nominal amount of $25,000 to put together the request for proposals and obtain the competitive bids Midway City required in the conditional use permit. Such costs clearly qualify as actual excess costs because they are clearly not required or necessary to RMP's proposed overhead route. Failure to pay any of the actual excess costs waives Midway City's right to impose excess costs on RMP. In the alternative, if the board determines against a great weight of evidence that the project is not necessary to protect the integrity of the electric transmission system or the utility customers of the Heber Valley, the board must determine, under the statute, the amount of estimated standard costs, actual excess costs, and the time period to pay such costs. To determine the standard cost, the Act requires the public utility provide the estimated standard cost of the facility and the estimated excess cost of the facility. Rocky Mountain Power provided the estimated excess cost of the underground line, which was rejected by Midway City in the conditional use permit. Rocky Mountain Power provided the estimated standard cost of the facility, the proposed overhead power line, through the testimony of Darren Myers, Ben Clegg, and Ben Lefevre, its real estate appraiser. Mr. Myers testified the estimated standard cost of building the overhead line was $1,886,601. The statute requires only an estimate of the standard cost and does not require a binding construction bid. Mr. Myers testified the standard cost estimate was obtained by comparing this project to a similar recently built project. This methodology is authorized by the Act in the definition of standard cost at Section 54.14.103.9b, where it states, quote, with respect to transmission lines, standard cost is the cost of any overhead line constructed in accordance with the public utilities normal practices, close quote. The question of right-of-way costs is difficult in this setting to estimate. To determine the actual right-of-way costs, it is true that Rocky Mountain Power would need to obtain the right-of-way with individual property owners through negotiated settlements or condemnation. In contrast to Midway City's position, the statute does not require the actual right-of-way costs, but rather an estimate. Several technical legal nuances make estimating the right-of-way cost difficult. The existing 50-year transmission line owned by Heber Light and Power was obtained by prescription and subsequently recorded by HL&P. Voters erroneously decided in their trial memorandum the width of the HL&P easement is 10 feet on either side of the center line. Mr. Norland at HL&P testified that HL&P needs at least 20 feet on each side of the center line to maintain and operate the easement. Therefore, the existing easement is at least 40 feet, but a Utah District Court would be required to determine the actual width of the easement. Rocky Mountain Power submitted evidence during the permit application process. The estimated right-of-way costs were approximately $25,000 based on obtaining 2 to 3 feet of additional right-of-way where necessary. Rocky Mountain Power's legal position is that the existing power line right-of-way can continue to be used as a transmission power line under the new project. In addition, Rocky Mountain Power moved the proposed overhead line slightly north on Ward's Lane to prevent from taking any new right-of-way on the south side of Ward's Lane. In other words, the southern boundary of the new power line would be the southern boundary of the existing HL&P power line. Therefore, there would be no new physical take on the properties along the southern side of Ward's Lane. Those properties comprise the majority of properties appraised by Mr. Weber, the appraiser for Midway City. Another fatal flaw in Midway City and Volt's right-of-way analysis stated in their trial memorandum is that the new 138 kV transmission line requires a 60-foot right-of-way. This is simply not true and is not supported by the evidence before this board. There is no provision in the National Electric Safety Code that requires a 60-foot easement for a 138 kV power line. Although it may be a good practice to obtain a 60-foot easement on new power line corridors, this is not a new power line corridor. This power line corridor has existed for over 50 years. The NESC requires vertical and horizontal clearances from existing structures. The right-of-way distance is obtained by complicated mathematical calculations that consider the vertical sag of the conductor and the horizontal movement of the conductor from the wind, the deflection of the pole when the horizontal wind is applied, the framing of the pole, and the required NESC clearances that must be maintained. It is not a 60-foot right-of-way width. Another fatal flaw in Midway City's estimated right-of-way cost is the erroneous assumption by Mr. Weber that properties not touching or experiencing a physical taking by the proposed power line can obtain severance damages. It is black-letter Utah law that there must be a physical taking in order for a property to receive severance damages. Mr. Weber's calculations include several properties where there is no physical taking. To account for Mr. Weber's incorrect application of black-letter Utah valuation and eminent domain law, Mr. Lefevre took the grossly exaggerated severance damages used by Mr. Weber and applied them only to the properties actually touched by the proposed overhead route. In his rebuttal testimony, Mr. Lefevre testified that using Mr. Weber's grossly exaggerated severance damages on just the properties where physical taking occurs amounts to between $691,344 and $767,712. Although RMP does not concede this is the proper estimate of right-of-way costs for the overhead line, RMP concedes that the best estimate available at this juncture of the project is most likely between $25,000 and $767,712, depending on the status of the prescriptive easement, whether it can be used as a 138 kV transmission corridor, the width of the existing 50-year easement, and the width necessary for the 138 kV transmission line. All of these outstanding legal determinations make obtaining an estimate of the right-of-way costs extremely difficult at this juncture of the proceeding. Because the Midway City permit rejected RMP's estimate of excess costs, the Facility Review Board Act requires RMP in Section 54-14-203 to obtain competitive bids. RMP did so. The Act then states that the actual excess costs of the facility shall be the difference between the lowest bid acceptable to RMP plus RMP's administration and oversight expense and the standard cost. First problem with obtaining the excess cost imposed by Midway City is the cost to acquire the right-of-way rights for undergrounding the line. Although several property owners have made non-binding overtures to donate the right-of-way free of cost, none of the property owners have entered into or offered any binding commitments to provide the right-of-way free of cost. The legal nuances with obtaining this right-of-way for the underground line suffer from many of the same legal nuances of the above-ground line, such as whether a 50-year-old HLMP easement can be used for the underground line. However, the unknown expense of the underground right-of-way cost is tempered by the true-up provision in Midway City's conditional use permit. Setting the right-of-way costs aside, using the lowest cost option to build the project underground of $12,646,665, less the estimated standard cost of the facility, which Mr. Myers testified was $1,886,601, and the estimated right-of-way costs of $500,000 for sake of argument, which totals $2,386,601. The actual excess cost of Midway City's choice to underground the line will be $10,260,064. Under Section 54-14-204 of the Act, this actual excess cost must be paid within 30 days before commencement of construction, which is defined as the project design and ordering of materials necessary to construct the project. Because the testimony supports placing this project into service immediately, the board should find that Midway City waives the right to impose the excess cost of undergrounding the line unless it pays the actual excess cost of $10,260,064 within 10 days of signing the final order. The clear and undisputed evidence in this proceeding is that the project is necessary to provide safe, reliable, and adequate service to its customers, and therefore the board should authorize the project to move forward immediately. That concludes my comments. Thank you.
Thank you, Mr. Wright. This is Thad LeVar. I want to ask you a couple questions, then I'll go to other board members. My first question is, in your view, is the need and timing of the line still a contested issue for the board to determine, considering the issuance of a CUP by Midway City?
I'm not sure I understand your question. Can you restate it?
Okay, I'll phrase it a different way. By issuing a CUP, did Midway give up its or waive its ability to contest the need for the line.
Yeah, I agree with that statement. I mean, I think in the actual conditional use permit itself, it states that there's a need for the line. I mean, I don't think that matter is disputed. And I think that issuing the conditional use permit is evidence of that.
Okay, I think I just have one other question at this time before I go to other board members. You know, the Facility Review Board Act clearly gives the board the authority to resolve disputes over costs, and Midway has the right to seek board review of any disputes between Midway and Rocky Mountain Power over costs. So considering that legal right exists, does that by implication give the board the authority, if it were this is just one person asking, but if the board were to consider resetting the timelines for the CUP and saying, as of today, the day we make this board decision, Midway City has 15 days from the date of the decision to select a route and 30 days from the date of the decision to pay the excess costs. Is that authority to reset those CUP deadlines inherent or implicit within our authority to determine costs or resolve disputes about costs?
Well, I know that the statute states that the board can address any dispute regarding specifications, lowest acceptable bid, or administrative and oversight expenses, and also can ask for additional information under the act. So, you know, I would tend to agree that the board does have authority to set new deadlines. I think there's actually a provision in the statute, I'm not sure where it is exactly, I can't find it right offhand, where the board can delay actually issuing a decision, ask for additional information, and put off the decision for a specific time period. So I do believe that the board has that authority.
Okay, thank you. Those are the only questions I have at this point. Do other board members have questions for Mr. Reich at this point?
Yeah, this is Jordan White. I think I'm asking maybe a similar question to what Chair LeVar was asking, which is, if I understand the potential alternative decisions in front of the board, is one potential decision to allow the city to a certain amount of time to pay, or I don't know what the legal function would be, whether it's bond for it, et cetera, or the actual excess cost. And if they were not to meet that deadline, the alternative would be that the city would, the Rocky Mountain Power would have the right to immediately begin construction with the overhead transmission line. In other words, is that under the statute? Is it your opinion that there's I guess like a dual decision, I guess, or a decision in the alternative?
I think that the answer to that depends on the finding of this board on whether or not the requirements or conditions imposed by Midway City, if I'm referring to Section 54.14.204, whereas there is the timing mechanism about payment, and it says that within 30 days before the date construction of the facility should commence. And then I think there's in order to avoid a significant risk of impairment. So I think that the board has to decide if there's a significant risk of impairment, then I don't think the board has discretion to change the deadline. I think that 30 days deadline is statutory. If the board finds that there's not a significant risk of impairment, then I think that would probably be a different story. But under the statute, it clearly states that upon a finding of a significant risk of impairment, then payment must be made within 30 days before the date construction of the facility should commence.
And if that were the board, if the board were to find that and the city did not meet that condition, and that was the finding, then what would Rocky Mountain Power automatically be granted the right to go to build to proceed with the overhead
Yeah, I think
construction.
sorry, I didn't mean to interrupt you.
That's my question, I guess, is that if that were the case, if we made that finding, if that were the case, and the city did not satisfy that order, what would be the result of that? Would it be that it would just automatically provide Rocky Mountain Power with the right to proceed with overhead construction?
Yes, the conditional use permit is written today, states that if the underground line is not an option for whatever reason, I mean, in the conditional use permit, it states that if the conditions aren't met, I think the board finding that the condition is not met, the payment was not made when it was required, then the conditional use permit is written today, states that Rocky Mountain Power will proceed with the overhead project, and then it contains conditions that I believe Rocky Mountain Power would continue to need to meet under the existing conditional use permit for the overhead line. So my answer is yes.
Yeah, thank you. That's all the questions I have for now.
Thank you, Mr. White. Any other questions from board members? I'm not hearing any, so I have one follow-up that Commissioner White's question brought to mind. As I asked a minute ago about your view of the board's authority, if we were to, under our authority to resolve disputes on costs, reset the CUP deadline, it seems like, you know, if we made a decision today, we could consider resetting Midway's deadline to choose a route under the CUP to 15 days from today. If the board were also to make a finding with respect to significant risk and reset the deadline for Midway City to pay the excess costs, is there a way that the board could calculate 30 days before the date of construction, before the date construction should commence? Is there a way that we can calculate now, if we wanted to reset that deadline from the CUP after determining what we consider the appropriate costs? Is there a way we could reset that 30-day deadline, since it's not a going forward 30-day deadline, but it's a going backwards from commencement date? I hope my question makes sense.
Yeah, I think to the extent I understand your question, that I think that turns on the definition of commencement of construction. And in order to push back a 30 deadline, or to set a 30 deadline from today, the board would have to find that commencement of construction is not necessary for 30 days from today's date. So the project design and ordering materials can wait for 30 days, and then I think that then would comply with the statutory authority granted to the board.
Thank you, Mr. Reich. Any other questions from board members? Okay, I'm not hearing any questions, so why don't we go ahead to Midway City for your closing statements.
Thank you, Commissioner. I appreciate the hard work that the board's put in. Just in the beginning, I'd like to say that this has really been one of the hardest issues that has ever come into Midway City. And there's tremendous amount of concern and hours that have been put into understanding and addressing these issues, and we appreciate all the work that the board's done to get up to speed quickly on this process. Now, in beginning, one of the things I do want to point out is the actual excess costs are really the core of everything here, because under the conditional use permit, we required them to provide competitive bids, and our responsibility to pay is not triggered until we receive those bids, so that the actual excess costs can be determined. I'm going to walk through today why it's impossible to determine the actual excess costs, meaning that Rocky Mountain Power still has not complied with the simple requirements under our conditional use permit. Now, with that said, when I started on Monday, I outlined the items that Midway City intended on establishing through cross-examination of Rocky Mountain Power's witnesses. And if you recall, I asked the board to pay attention and to hold me accountable for the things I said that we would show. As my closing, I'm going to walk through what I told you I would prove and what actually came into the record. As you recall, I told you that this board has two jobs today. The first one is to determine what the actual excess costs of going underground are, and number two, what the appropriate commencement date should be for Midway City's portion of the line. In order for this board to determine the actual excess costs, you need the standard costs, you need the actual cost to go underground to be verified by reliable bids, and then you need the actual costs of the easements. I'm going to address each one of those in turn. So first, I told you that we would be able to show that there's really no reliable evidence necessary to establish the standard costs. And the evidence shows as follows. Rocky Mountain Power has not submitted any bids to establish head costs. Rocky Mountain Power put on Mr. Myers, the project manager, who testified similar lines would typically be estimated at about 190 to 250 per foot range, but that was not supported by any form of external documentation or bid. He also stated that the actual cost of a similar double circuit overhead 138 kV transmission line project that was finished in March 2019 came in at $269.90 per foot. This was also not supported by any documentation from the other project, was without any indication how the project was similar and lacked any indication of reliability. He acknowledged that even with his estimates, they do not include surcharge costs or costs of the easements, which the definition of standard costs require. And based on that information that we have before us, Rocky Mountain Power is asking you to determine what the above ground costs should be. It is our position that there is insufficient evidence on the record necessary for this board to even remotely determine what the standard costs to go above ground are, and that additional information is needed. Under Section 5414-103, it defines that with respect to a transmission line, standard cost is the cost of any overhead line constructed in accordance with the Public Utility Standard Practices. Under 2023A, it states, if the board finds that the public utility has failed to provide the standard costs and estimated excess costs in accordance with the provisions of subsection 1, the board may request additional information from the public utility. The public utility then has 30 days to provide that information. And if they do not, then this hearing can be postponed until the information is obtained. Rocky Mountain Power has not provided this information to Midway City or this board, and as such, the board cannot determine what the standard costs of the project are. So based on the first prong of your responsibilities today, you do not have the evidence or reliable evidence necessary, in my opinion, to give you comfort that what you're establishing as standards costs are based on anything more than just kind of speculation. Next, regarding the below ground costs, I stated, due to serious mistakes in the specifications given to the 3 approved contractors who bid to bury the line, the bids have come in anywhere from $3 million to $5 million high. Let's see how I did on getting that into the record. Mr. Myers, who has only been on this project for a year and testified that this was his first underground line, I think, bid process, openly acknowledged that he did not catch problems in the bid. He testified and acknowledged that the measurements in the bids included approximately 1,600 feet of length that was not supposed to be trenching. This length was supposed to be cable only on the dip poles. Mr. Myers admitted, and the actual bids show, that 2 of the bidders actually bid the additional length as trenching. The evidence on those bids show that the mistake was made on all of the options by 2 of the bidders. To give the board a sense of the scope of the error, in the shortest option, the extra 1,600 feet is 24% of the project and creates a discrepancy of over $3 million. In a conditional use permit, Midway City asked for what we thought was a very simple thing: 3 competitive and reliable bids. What it received was one bid to the specifications issued by Rocky Mountain Tower and two with gross mistakes that overestimate the cost by up to 24%. At this point, it is unclear whether the low bid is actually accurate or if the other two bids would have come in lower if they had bid the specifications correctly. And I remind the board that Midway City's obligations under the conditional use permit to pay are not triggered until this requirement is met. Once again, Midway City has not received what it asked for, and this board has the power under Section 54.14.2023A to require Rocky Mountain Power to provide this information. And we request that you exercise this power and require Rocky Mountain Power to obtain 3 bids based on accurate specifications. Next, in my opening, I stated, we will show that Rocky Mountain Power has included several items in their bids that have no justification from a safety nor reliability standpoint. First, Rocky Mountain Power put forth specifications that require dual trenches to bury and separate the 138 kV line. There is no safety standard that requires dual trenches, and no justifiable reason to have 2 trenches, especially where it doubles the cost that RMP wants Midway and its taxpayers to pay. And Rocky Mountain Power specs require an extra conduit to be installed on each circuit, and there is nothing in any industry standard that requires this extra expense, yet it increases the cable cost by 1/3. So let's look at the evidence and how I did on my promise to bring that into the record. First, Rocky Mountain Power did not present any witness who was really qualified to testify as to the necessity under the National Electric Safety Code that a dual trench is required. In fact, Rocky Mountain Power did not present any witnesses really qualified to discuss Rocky Mountain Power's standard practices under the NESC or its own. Benjamin Clegg testified he talked to someone the morning of his testimony and obtained some references in the NESC, which really established nothing more than the fact that he did not refer to these specifications prior to this when acting as the project manager. He admitted as project manager that he receives this type of specification and information from the standards division of the company. Mr. Meyer, current project manager, testified he was in charge of the creation of the specifications included in the bids, but then stated he does not come up with the company standards nor the NESC compliance regarding the specifications in the bids, and that those come to him from the standards division of Rocky Mountain Power as well. He acknowledged that the only specification he actually created was the length of the trenching, but could not testify to safety requirements or reliability requirements of dual trenches or pulling an additional deadline through the extra conduit. Jake Barker, the Director of Transmission Planning and Power Quality for Rocky Mountain Power, testified that he was not aware of any NESC standard that requires dual trenches. Rocky Mountain Power curiously offered no testimony from its standard department, who actually created these specifications, regarding whether dual trenches are required under the NESC or whether the extra dead cable was required under the NESC. Midway City submitted testimony from John Nelson, an expert in burying transmission lines for 50 years, who stated that nothing in the NESC standards prohibit 2 utility companies to share a trench. He also testified that there is nothing in the NESC that requires the extra cable to be pulled in the empty conduit. He testified that once the length errors of the bids are corrected, that the dual trenches are changed to a single trench, and the additional cable is removed, the cost to bury the line would be $6.3 million approximately, instead of the low bid of $11,187,986. I also told you that when we were done showing all of this evidence, which we did, we kept our promise to you, that we would ask you to either adopt our experts' valuations as the underground costs or require Rocky Mountain Power to provide bids based on correct specifications and also trim the fat of luxury items. Specifically, we ask today that Rocky Mountain Power be made to comply with the conditional use permit by providing 3 qualified and competitive bids that, number 1, are based on correct lengths of trenching in the specifications, remove the requirements for dual trenches, and remove the requirement for the additional cable pulled through the spare circuit. Without this information, there is no way for this board to determine what the actual cost of burying the line below ground would be, and so on the second prong, it states our argument is that you still have insufficient information needed to make that decision. Next argument. Regarding the cost of the easements, I stated, there is nothing in the statute that suggests the actual cost of the easements can be determined by estimate. Once they are obtained, the actual estimates of the easements will be established and can be submitted to the board so that the actual excess costs can be determined. And I want to highlight here for you commissioners that this is perhaps the most important legal determination that you're going to make in this matter. Section 5413-103, and I'm just going to pause and pull that up here real quick, defines that the actual excess cost means the difference between the standard cost of a facility, which we say you do not have sufficient information on, the actual cost of the facility, which is allowed to be established by competitive bid, and the actual cost of any necessary rights of way, which you do not have information on. It states that the actual cost of the facility will be established in accordance with Section 203. Section 203 sets forth Midway City's right to request the public utility to obtain competitive bids for the facility if constructed in accordance with the requirements and conditions of the local government. I want you to note that it does not say competitive bids for the easements, but only the facility. Facility is defined. It says facility means a transmission line, a substation, a gas pipeline, a tap, a measuring device, or a treatment device. This definition does not include easements. While the statute contemplates establishing the costs of the facility through competitive bids, it does not extend the same process to obtain actual costs of easements. For example, it would be nonsensical to say that you could establish the actual cost of easements by competitive bid. If the statute allowed excess costs to be established by estimate, it would have provided a path to obtain these estimates, which it clearly does not. All it says is that in order to determine the actual excess costs, you need to obtain the actual cost of the facilities, which can be obtained by competitive bid, and the actual costs of the easements. The only way to obtain the actual cost of the easements is to either settle with the landowner or condemn. Based on this, we ask this board to make a legal finding that under this statute, the actual easement costs cannot be established by estimate, and request that Rocky Mountain Power provide the actual easement cost before this board can determine the actual excess costs. And we ask you to take care in really creating a record there. I think this is one of the most important legal issues that, interpretive issues that you've got. If the board does choose to interpret the statute as allowing easements to be established by estimate, we simply ask you that you give careful care and put forth your legal reasoning on it. Further, if that is the interpretation the board chooses, Rocky Mountain Power has failed to provide any reliable information on what the actual costs of the easements are. First, there's a distinct dispute of fact regarding what the actual width of the existing easement is and how much needs to be obtained. Measurements were given to Mr. Lefevre by Rocky Mountain Power, but nobody seems to know where the measurements came from. Mr. Lefevre testified that his analysis was specifically not directed at giving actual values of the easements. He gave a range of 25% to 75% of the underlying value without applying that to any of the impacted properties. He used studies from Salt Lake that he admitted were not necessarily applicable, but were the best he could get. He did not perform appraisals on any impacted property and admitted he was not aware the size of the poles were not a nominal but significant difference. Basically, his testimony was rendered mostly useless due to admitted lack of specificity and reliability. He himself admitted the board could not use his work to establish the actual costs of the easements. This board is left then with either accepting Mr. Weber's testimony as to the value of the easements or to require Rocky Mountain Power to obtain appraisals on each impacted property so that a better estimate of actual costs can be ascertained. Of course, the problems of establishing the actual costs of easements through appraisals is highlighted by the fact that Rocky Mountain Power first proposed the easements were worth $27,000. Their expert testified to a broad range that could be somewhere between $300,000 to over $1 million, and Mr. Weber testified to $3.4 million. Is it any wonder that the statute does not allow actual value to be established this way? Appraisals can be manipulated to the point of destroying any sense of reliability which is why the statute does not allow it. So in summary, this board has the power to request information that was supposed to be submitted by Rocky Mountain Power but was not, and also has the power to suspend the hearing until the information is provided. Once the missing information is provided, the board has 30 days to issue a decision, and we ask the board to exercise this power, requesting updated bids and the actual cost of the easements before reconvening. Next, regarding the appropriate commencement date, I stated that Midway City wants the opportunity to bond, which would require the commencement date to be extended to spring 2021. I stated, we will show that Rocky Mountain Power's own studies establish there is no immediate risk to its customers if the line is delayed a few months to bond. The area is currently served by 3 different transmission lines, and RMP's own experts will establish that the claimed threats of system failure, once analyzed, are so remote as to be non-factors. The evidence will show that neither Heber Light Power nor Rocky Mountain Power system is currently exceeding acceptable loads, and that neither will do so through the end of 2022. So let's see how we did on getting that evidence into the record. Mr. Barker stated that there has not been a situation where Rocky Mountain Power customers have been without power due to a failure of any of the transmission lines in questions for at least 20 years. He testified that in the past 20 years, he is only aware of 2 major incidents with the lines, a helicopter crash and a mudslide, but neither resulted in the loss of power to Rocky Mountain Power customers. He testified that even in the case of a significant natural disaster, where a mudslide cut service for 37 hours in Provo Canyon, none of Rocky Mountain Power's clients went without power. Jason Norland testified that in his 23 years with Heber Light and Power, the Provo Canyon line has only been down a total of 2 to 3 days collectively, with the longest of those outages from 6 to 7 hours. If you take the length of his time at Heber Light and Power at 23 years, that's 1,400 hours of service that this line has been working. In that time, the line has been out a total of 3 days or 36 hours collectively. That is 0.00017% of the time, which is a real-life way to determine the actual risk of an extended outage on this line. Now, I want to emphasize that I'm not saying that a major catastrophe could not occur. But the reality is, if a major catastrophe does occur, like an earthquake, it is far more likely that all of the lines involved could go down, meaning that the risk is no greater and no less if it takes a few extra months to bury. Jason Norland testified that the north line can handle the load while the south line is rebuilt, which is the plan already. They're already going to do that. While this is not ideal for Heber Light and Power, it is willing to accept this risk while the south line is built. There's no way to avoid it. An increase of 6 months does not significantly increase the risk Heber Light and Power is already assuming in building the south line. And finally, all of this is an academic exercise in the first place because Rocky Mountain Power has not obtained any of the needed easements to commence the line in any of the jurisdictions the line passes through. There are 7 miles of easements that need to be obtained, and the conditional use permits in Wasatch County, Heber, and Midway City all prohibit Rocky Mountain Power from commencing construction until the easements are obtained. So the likelihood of this line even starting in 2020 is low, and being finished in 2020 an outright impossibility. Benjamin Clegg confirmed that there is no possibility the line would be finished by the end of 2020, and he also testified that weather conditions could prolong the installation and push it farther into the spring of 2021. He stated that none of the poles have been ordered and none of the easements have been obtained. I think he said that they were working on some of the easements, but the vast majority of the easements have not been obtained for any portion of the line. He stated that the easements normally take up to 6 months to obtain and that the poles take anywhere from 7 to 9 months once ordered to be received. This means that the likelihood of even starting this year is 0. Rocky Mountain Power can't order the poles until they do soil samples, and they can't do soil samples until they know where the easements are going to go. So realistically, even under Rocky Mountain Power's best case scenario, easements could be obtained by October, and the poles ordered that would arrive in a best case scenario in May of 2021. This means that construction would start on the north end of the line, some 6.3 miles away in the spring, and continue to Midway, where the line could be buried in the fall. The evidence shows that this line is going to be doing well if it's installed by the end of 2021, which means Midway City could and should have the chance to bond fund the excess costs, and have its portion buried without even interfering with Rocky Mountain Power's critical path. All Midway City is asking for is a chance to put a bond on the general election in November. As I stated before, we're really arguing about nothing because the line is not going to commence until the easements are obtained. I do want to point out that this line has not been delayed by Midway City. Rocky Mountain Power has had approval from Wasatch County and Heber City for almost 6 months to go overhead, but have done little to nothing to obtain the needed easements to commence. And this is not Midway City's fault. But Midway City should not be punished for Rocky Mountain Power's failure. If the reality is Rocky Mountain Power cannot install this line until the spring of 2021 due to its own failure to obtain needed easements, why should Midway City be punished? In reality, we are simply asking to take advantage of the timeframes Rocky Mountain Power has imposed on itself. Nothing we are asking hurts Rocky Mountain Power or increases its critical path, given the realities of things they still need to accomplish in order to proceed. Now, that's the evidence that we submitted. A more overarching discussion that I want to have is why this board actually exists. This board is established under the Public Service Commission with the emphasis on public. The reason this Public Service Commission exists is because our nation doesn't like monopolies. Monopolies are dangerous, and the only way we allow them to exist is with public oversight. They are large, powerful, have tremendous competitive advantages, are profitable enough to attract the likes of Warren Buffett to buy them, and have the distinct capacity to do things that can be very damaging to individuals and communities. This board specifically exists to check the power of the monopoly, to hold the monopoly accountable under the law, and to assure that the public generally is not being abused by its actions. Rocky Mountain Power requested this hearing, yet has not provided the fundamental evidence this board needs to determine the actual excess costs. It gives the board no reliable information on above-ground costs, seriously flawed underground bids that include arguably luxury items that it wants Midway City to pay for, and provides no reliable evidence as to the actual cost of the easements. It acts this way and then wonders why Midway City citizens are upset and feel powerless. In regards to Midway City citizens most impacted by these lines, Rocky Mountain Power has put on witnesses that state that there is only a nominal difference between a 2-foot diameter and 50-foot tall pole and a 90-foot tall, 8-foot in diameter metal pole. These types of statements are not credible and not fair. And if that pole were set in front of that person's home, you can bet the company line would suddenly shift dramatically. This is why this board exists, so that when monopolies that are clearly driven by the lowest cost and highest profit margin take offensive and unreasonable positions, like the easements in this case are only worth $27,000, or that homeowners who will have gargantuan poles in their front yards are not entitled to severance damages, that this board can say, wait a minute here. Wait just a minute. Mr. Monopoly, if anything, I'm going to hold you to the highest standard of the law due to your competitive advantage. If a statute says you have to provide information to a city, you are going to provide it without question, without argument, and to the fullest extent required by the law. They are entitled to it, and you are going to give it to them. Again, I remind you, Mr. Monopoly, that you have the state-sanctioned power to condemn individuals' property. And if there is a way that these property owners or a town wants to bury a line and to pay to bury it, and it can be done in a way that does not impact your timelines, I'm going to make sure they get that chance. Now, if this board doesn't say it, no one will. I have dozens of citizens watching this proceeding today whose life will change based on the decision of this board. One path is a long and bitter battle over condemned easements and above-ground power poles. The other path is to give Midway City the time to bond and to bury. In the first scenario, Rocky Mountain Power wins at a crushing cost to Midway City and its impacted citizens. In the second scenario, Rocky Mountain Power loses nothing, and Midway City wins, but we need to look at what they win. All they're winning is the opportunity to pay millions of dollars to bury a line. In many ways, you would think that it might be a little crazy that a group of citizens or a city would fight this hard to pay an extreme amount for something that they could get for free. But that's how much they care. And if you could look in their faces, which you would normally be able to do in this type of a scenario, you would see how much they care about this. The nice thing about our current situation is that the law is on their side, and the law requires that this board and Rocky Mountain Power care as well. All we're asking this board to do is to enforce the provisions of the code and require Rocky Mountain Power to provide the appropriate information so that we can get a straight answer on what the actual excess costs are, so that all of the other dominoes can fall. Once we know how much, we can begin to move forward to raise the money, bond for the money, possibly even receive a loan from Heber Light and Power. We cannot do that until we have that information, and this board has not been provided it, and neither has Midway City. Based on that, I would submit.
Thank you, Mr. Gordon. This is Thad LeVar. I think I just have one question for you at this point. What should this board view as a legal consequence of Midway City not acting on the CUP application within 60 days?
Well, I mean, I think that that's a right that Rocky Mountain Power has to enforce, but they have to challenge it. And so they basically have waived the objection. If they wanted to raise that, they could have raised it a long time ago. They have now raised it, and we're now here, and we're showing to you that we can't act on their application without appropriate information, and they haven't given it to us. It's never been provided. So either way, I mean, they raise the issue and say, you're supposed to do this within 60 days. Well, we're only supposed to do it if we have the information, and we can't. So, I mean, that would be Midway's position on that.
Thank you. Just to follow up then, is it your position that Rocky Mountain Power should have raised the issue to this board as soon as the 60 days expired?
Yes. I mean, I think that that's within their right, but they can choose how long they want to wait to raise it. And so they have now raised it, and we're here arguing it and addressing it in this hearing. And the evidence shows the reasons why we didn't are justified because we don't have the information necessary to act.
Okay, I'm sorry. That leads me just to one follow-up, though. But didn't the terms of the CUP that was ultimately issued by Midway demonstrate that the CUP had the ability to request the necessary and the information necessary to act? I mean, you issued a CUP that said we have to have 3 bids. So why couldn't that have been done within the 60-day deadline? Was there any more information available to Midway City when the CUP was issued that wasn't available within the 60-day time frame?
I don't think so. Let me kind of think that through here for a second. And my mind's kind of wandering all over here. So I'm sorry. Can you kind of just? I'm sorry. I'm trying to do this in real time. Could you just ask me that question again so that I make sure that I'm answering it, answering what you're actually asking me?
Sure. It's kind of a stream of consciousness question that I was trying to put together on the fly. So I'll try to rephrase it. You said that the delay in acting on the CUP application was due to a lack of information. But the CUP that was ultimately issued by Midway simply called for that information to be provided. So was there any information that Midway had when it actually issued the CUP that it didn't have within the 60-day period that the law required it to act on the application?
Yes. I mean, clearly there was information coming in while this was pending before the city in every hearing. There were requests to establish easement costs that came in far beyond the 60-day. There were questions regarding what the design would be on an underground line. There were requests made to determine what the length of the poles would be, how far apart they would be. All of that came streaming in over time and was far beyond the 60-day time limit in this situation. So The answer to your question is yes. There was information received all the way through, far beyond the 60-day limit.
Thank you. You know, I did have one more question that's unrelated to this, and I apologize if this question is in the testimony and I just have forgotten where it is. Are you proposing a specific commencement of construction date? You've said in your closing statement, spring of 2021. If we were to issue an order, obviously we have to be more specific than that. Are you proposing a specific date if the board were to decide to give Midway the opportunity to put it on a bond election in November? What do you have something more specific than spring?
Certainly, yeah. And so let me just explain. The dominoes on that one would be the bond would be passed in the latter part of November. We would not be able to fund it until probably January into February. So in order for Midway City to be able to pay the actual excess costs, the time frame would need to be somewhere along the line there. And Midway City is just fine. I think there was a discussion from Commissioner White. If the bond doesn't pass, then the line goes aground and there's not going to be any argument there. If the bond does pass, then we would ask for a commencement date. Probably March 1 would be safe. And once again, we're not asking that the other portion of the line be held up. Construction can begin on that as soon as they want. But I think March 1st is a reasonable and fair estimate of when we think we would have the money.
Thank you. Okay, I'll go to other board members for any questions for Midway City. Okay, I'm not hearing any questions from board members. I'm trying to decide if we should give our court reporter a break before we move to Volt's closing statements. I think what we'll do is we'll go ahead with your closing statements and maybe we'll take a break before questions. So if anyone objects to that, speak up now, including Ms. Berry. But otherwise, I think we'll go ahead and go forward with Volt's closing statement and then probably take a break before questions. Mr. Morris.
Thank you very much, Mr. Chairman. Good morning. May it please the board and Mr. Chairman, council, and board members. My name is Mark Morris, and it's been my privilege for a long time now to represent a number of families in Midway who do have the concerns that Mr. Gordon just described to you. And they've had them ever since they first learned of Rocky Mountain's plan to run a high voltage transmission line right through the middle of a rural picturesque valley. Contrary to what Rocky Mountain has suggested to the board, it is not Rocky Mountain Power's way or the highway. The scores of families along this route in Midway have made known their not just their desires, but their willingness to back up these concerns and desires with money out of their own checkbooks in hiring me, in hiring experts, and in offering up easements and rights of way without charge, so that their reasons for coming here and living in Midway will be maintained. I want to join Mr. Gordon in thanking the board for granting my clients the ability to intervene in this matter and to present these concerns and also test the evidence and challenge the burden that Rocky Mountain Power had in order to obtain the relief it seeks in this proceeding. My clients want power, too. They don't want to have their TV turn off in the middle of the Super Bowl. They don't want to have food in their fridge spoil because they don't have power. But there has been no showing of any kind that there is an immediate need I think it is undisputed that, upgrades are necessary as time passes. And I think the evidence is clear that what Rocky Mountain is proposing to do here is not a frivolous thing or an unnecessary thing. But the idea that it has to be done now or last year or 2 years ago is nowhere in evidence. And I won't repeat all of the evidence that Mr. Gordon cited to the board showing the lack of an immediate need. There is no prejudice to Rocky Mountain Power, and I'll allude to this at the conclusion of my statements here. There's no prejudice to Rocky Mountain Power or to its ratepayers or to anyone in the Heber Valley if a more thoughtful and considered approach to this critical issue is required by this board. And that's the obligation we feel the board has here. I want to begin by saying that the relief Volt and its constituent members ask here is precisely what Mr. Gordon enunciated, that this board deny Rocky Mountain's petition and simply require Rocky Mountain to comply with the statutes. I don't think Rocky Mountain would argue that its only obligation is to throw two numbers on the board and say, you have to accept this now, and we'll true up in a couple of years when we know what the real numbers are. I don't think even Rocky Mountain would suggest they could come in here with a flimsy estimate on easements when the number is far greater and say, you just have to take it. And you have to write an enormous check, even though at the conclusion of 2 years of condemnation fights and litigation with 40 or 50 landowners along this route might result in them having to write a bigger check and refund some of the actual excess costs that they were claiming. That's silly. And we join in Midway's argument that what is required is not an estimate of $27,000 that their own expert testified to you yesterday was nowhere near what he thought the easement costs could be. $27,000 was an insult and an invitation, and it was a flagrant dare to say, you're going to have to just write an enormous check if you're going to buck us in our desire to go through and build this line through your rural picturesque valley. The essence of the conditional use permit was for Rocky Mountain Power to provide Midway with a fair opportunity to make an informed decision on whether it wanted to pay excess costs. Even today, after 2 days of evidence, does anyone know what it's going to cost Rocky Mountain Power to build a line and go overhead? Does anyone know what a reasonable and true expense of going underground is going to be in this case? If the answer to those questions is no, and the evidence says it's no, then Rocky Mountain did not comply with its obligation under the conditional use permit to provide Midway and its citizens with a fair opportunity to know whether they wanted to come out of pocket and avoid these gigantic poles being planted through people's neighborhoods here. Let me begin with this idea of the easement. Mr. Reich testified that our claim that we need a 60-foot easement for 138 kV lines is unfounded. And yet, if the board were to look at Volt Exhibit number 12, and option B, Rocky Mountain's own proposal says there is an existing 46 kV right-of-way of 27 feet from the center line. So Rocky Mountain Power told bidders and is telling the world there's already a 54-foot wide easement. Well, that's what they said in their paperwork, but we heard Mr. Wright concede that, well, maybe it's only 40 feet. That's what Mr. Norland thought. But when I asked Mr. Norland how many feet he had, he said, as much as you need for a 46 kV line. He didn't put a dimension on it. But looking again at Bold Exhibit 12, underneath where Rocky Mountain has identified what it claims to be the existing easement width of 27 feet, they say 138 kV right-of-way, 29 feet from the center line. So Rocky Mountain Power, in its own papers, admits it needs at least 58 feet to run these 138 kV lines. The prescriptive easements that Heber Light and Power didn't buy, didn't pay for, didn't negotiate, are by prescription. And the mere fact that Heber Light and Power filed something in the county recorder's office that said we have a prescriptive easement does not give a dimension to that. And I think Rocky Mountain Power concedes that it could be an expensive and complicated process to find out what those easements are. Well, that's the burden Rocky Mountain Power has. It's not up to the landowners to come in and prove what they have to give up. It's up to Rocky Mountain to prove what they have and what they're going to take. Now, Mr. Myers, Mr. Michaelis, and Mr. Lefevre, presented by Rocky Mountain Power for their respective propositions, were not the people with firsthand knowledge of the topics they were testifying on. The board understands we objected to Rocky Mountain choosing not to bring in the real bidders, not to bring in someone who had actual on-the-ground experience talking to homeowners on the line and doing inspections there, but rather people who looked at reports, looked at bids, passed on them, and said, looks good to me. The board, you did not hear from a single bidder, from a single workhorse on the appraisal report. Anyone that had the firsthand knowledge and experience that this board was entitled to hear from, and that due process and fairness and justice required Rocky Mountain to present. Why was Rocky Mountain unwilling to bring in the real people instead of the 80,000-foot elevation people looking down on the people on the ground and saying, looks good to me? We asked the board to focus on the evidence, some of which, well, most of which was pure hearsay. Review the record, and I want to just go through these witnesses and identify 2 or 3 things that I think were critical for each of them. Rocky Mountain Power started with Mr. Barker, but I want to end with him. Mr. Clegg, he said that there was a, quote, nominal difference between 46 and 138 kV lines. We submit, if you look at the same picture I showed him, nominal is not a word that comes to mind when you look at the difference between the pole's width, dimension, and height. Mr. Clegg also took upon himself the job of being a rebuttal expert to an appraiser. I don't know I don't know what possessed him, candidly, to think that in his position as a former project manager, it was his job to examine Mr. Weber's opinions and try to rebut them. But I think the board saw that his rebuttal was premised on things that he hadn't even read, that mistakes he thought he had detected in Mr. Weber's testimony were in fact acknowledged by Mr. Weber on page 5 of his direct testimony and made known. but he missed that. I respectfully submit Mr. Clegg's testimony as to the nominal difference between 46 and 138, and to challenging the opinions of Mr. Weber, a certified MAI appraiser of many years, who yesterday told the board about conversations he had with landowners, with Midway Planning, with real estate agents. The idea that Mr. Clegg felt he could rebut that hard work and on-the-ground research simply isn't credible. Mr. Myers, well, he provided specs and he received bids, but this board does not know and will never know, without hearing from the bidders themselves, how real or measured the bids were. We understand from Mr. Norland that at the February 10th bid meeting, only 4 of the 18 invitees bothered to show up. Why? Well, Mr. Norland reported to the board of Heber Light and Power at their May 4th meeting that he thought the bidders had come in there and they had concerns, like, we're wasting our time. Why bother doing this when we know Rocky Mountain Power wants to go overhead? And one of those 4 threw in the towel even then. There's no need. Mr. Myers said that he doesn't think there's a need for 2 trenches. You just need 2 duct banks in 1 trench. Mr. Michaelis said that the north line is a beautiful, reliable line. He's not worried about anything going wrong there, and that 2020 is not an emergency situation. As Mr. Gordon mentioned, 2020 is in the rear view at this point. It's not going to be finished this year, and there are no red flags or flares going up about a dire emergency of people being out of power. Going on with Mr. Norland, as I mentioned, the bidders came in skeptical. He testified that the line that this line that is proposed to be built can be expected to be there for 50 years or more. And I think that's an important thing for this board to keep in mind, that the decision it makes now isn't going to determine what happens in 2020 or in 2021, but what this valley is going to look like for the next 50 years. That's consequential and important. And he testified that he never told Rocky Mountain Power that there was an existing 54-foot easement, as Rocky Mountain Power has described and as Rocky Mountain Power has told its experts to rely upon in going forward. Mr. Lefevre, I thought, was a good sport. In terms of, in spite of his minimal, he readily acknowledged his minimal involvement, his putting maybe 10 hours into a project that he said his other worker bees had devoted many hours to. But when cross-examined about whether he really thought it was a modest increase from a 46 kV line to a 138 kV line, I think we all heard him. I would have liked to have seen him chuckle and suggest, well, maybe modest isn't the right word to describe the difference between those poles. And he, too, had no idea who had provided him with the assumption that there is a 54-foot existing prescriptive easement on this line. Mr. Nelson was interesting, I thought, because he literally was thinking outside the box. He presented testimony and a different approach to how to lay a line underground, and he testified that it was in the $6 million range, not 12, not 18, and certainly not $28 million. It was credible. He was cross-examined on the point, and there was no evidence to suggest that his estimate was any different from what a bid would come in at. Mr. Weber did a detailed investigation with homeowners, real estate agents, Midway Planning. His estimate of an additional $3.4 million being needed to compensate these people for the taking of their property for an adequate easement, an easement with a metric that Rocky Mountain itself has suggested it needs, and to compensate the people for the loss in the value of their land, which even Mr. Lefebvre agreed would be I think his characterization was an after impact value. Two people you didn't hear from, but whose testimony is in the record, Ron Lowry. Rocky Mountain chose not to cross-examine him on his testimony that he suffered a loss of over $100,000 in the sale of his land because the people buying heard about the threat of this line and were not willing to pay fair market value. Mr. Lowry also said he would have been happy to give up an easement for the price of a clear sight line and not having these poles and lines running through his property and neighborhood. Bank Johnson gave detailed direct testimony in writing, and I asked the court to review it, the board to review it again. Mr. Johnson has devoted hundreds of hours of research that is easily inferable from what you read in his testimony. He represented and represents 53 members of Volt who have come out of pocket with cash donations, payment for lawyers, and surrendering easements on their properties. He showed, too, that's undisputed, and Mr. Norland admitted this, HLP has not maintained these prescriptive easements in any meaningful way. Mr. Norland said, well, if we have to get in and do some work, we may have to chop some branches down. But there are trees, tree houses, and the photographs that are in the record show that what exists now is nowhere near 20 feet on either side of a center line, and it's not even 10 feet in many instances. Mr. Reich, in his closing, indicated that there's no evidence that all these people are willing to give up their easements in favor of an underground line. Well, we have Mr. Lowry and Mr. Johnson indicating that's a fact, but, you know, Rocky Mountain Power, if it had chosen to speak with a single landowner in all of this process, it would know the truth of those statements. It's not the obligation of these people to come in and deliver signed papers at this point saying, I'm going to give this up if you'll do the right thing, Rocky Mountain Power. Rocky Mountain Power can go knock on a door or make a phone call and hear it for themselves. Finally, Mr. Barker, who was their first witness. There's only one thing that he said that I thought that really caught my ear, and that is Rocky Mountain Power is agnostic about going underground or going overhead. Well, let's take Mr. Barker at his word that Rocky Mountain Power is agnostic. But the numbers that the board has heard today, and candidly, I don't think the record would support the board making hard findings on values today. But the math on the numbers that have been presented to the board are such that if Mr. Weber's testimony turns out to be true, and if Rocky Mountain's overhead estimate of $1.8 million is true, that puts the cost of going overhead closer to $5 million. And if the underground cost is $6.8 million, as Mr. Nelson testified, then you're only looking at a delta there of $1.8 million, which is a far cry From the $10 million, Rocky Mountain claims it is entitled to get a check for and deposit into its bank in order to proceed with what the evidence should tell this board is an inefficient and unproven in terms of reliable, actual, efficient cost method of going underground. To be agnostic, you cannot underestimate the overhead line costs by saying that easements and rights-of-way will come in at $7,000, and then say, well, we'll true it up after we've built this line that is going to mar your valley for 50 years. Just as you can't start with a $70,000 estimate and end up later agreeing that what you claimed was worth $70,000 was actually worth $2.5 million in the SITLA example I provided to the board. I'd like to think that Rocky Mountain Power isn't intentionally being underhanded with this. I understand they have a profit motive. I understand that they fly the banner of trying to save their ratepayers money. But Rocky Mountain had a burden to come in and persuade and establish to this board that the numbers it provided in connection with the conditional use permit were reliable and reasonable. They did neither. You cannot overstate the excess costs by having a bidders meeting just a couple of months ago and tell them that they have to be done this year. All those bidders said, we can't do it this year. The board cannot believe that a $28 million bid to bury a mile-long line is a bid that Midway City was obligated to take seriously and consider in whether to write a check for the excess costs. So what my clients asked the board to do is require real evaluations of what the right-of-way and easement costs will be. Let's invite bidders and give them time and a real expectation of going underground. Let's invite Midway and Volt to help in the process by writing checks and giving up property rights to protect a beautiful environment, one that is increasingly being inhabited by families moving into homes rather than just having barren fields affected by this. And lastly, let's not make a mistake that the people in the good city of Midway will regret for at least the next 50 years. We respectfully request that the board deny the petition and put Rocky Mountain Power to the work it was obligated to do long ago and give Midway a real choice with real numbers and reliable numbers that it can make a decision and its citizens can make a decision on to determine what this valley is going to look like for the next 50 years. Thank you for your time.
Thank you, Mr. Morris. This is Thad LeVar. I think we'll take a 15-minute break at this point and then return for any final board questions and then board deliberation and discussion. So we'll be in recess for 15 minutes. Thank you. At this point, I think we'll go to any board member questions for Mr. Morris based on his closing arguments. If any board member has any questions for Mr. Morris, please jump in and indicate your questions.
This is Glenn Wright. Mr. Morris, you've indicated in the past that Bolt has raised a fair amount of money. How much could you come up with in cash if the decision was to go forward fairly soon?
My understanding, based on Mr. Banks' testimony, is that we're at about $650,000 at present.
Thank you.
Mr. Johnson, it's Bank to Johnson. I think I said Mr. Bank. I apologize.
Thank you, Mr. Wright. Any other questions from board members for Mr. Morris?
This is Dave Clark, Chair LeVar. Are you going to permit us to question other counsel in relation to arguments that have been raised? In other words, is there going to be a point in time when we can address any questions to any of the counsel who have argued?
I think probably now is the time for that.
So if you'll permit me to do that, I have a couple of questions for Mr. Reich.
Okay, go ahead. Mr. Reich, are you on the line?
I am.
My first question relates to Midway City's argument regarding the responsibility under the statute of the utility to present the actual costs of easements. And what I'm interested in what you think, if you have anything more to say to us on what that responsibility means. And I'd specifically like you to address the arguments of Midway City's counsel on what Midway City's interpretation is.
Sure, I'd be happy to do that. Thank you. So if you look in the definition sections of the statute in 54-14-103, 9A, it defines standard cost. And the definition of standard cost means the estimated cost of the facility, including any necessary right-of-way, if constructed in accordance with, and then it identifies some different requirements. So it's our position, and I think if you carry out kind of the natural conclusion of what Midway City is asking, I think it would support this. It's our conclusion that it's the estimated cost, not an actual cost. I do agree with Midway City, the only way to determine an actual cost, and I believe they even said even an appraisal is not an actual cost, is to actually go out and buy the rights of way. So what they're asking is basically for Rocky Mountain Power to go out and buy rights of way on a project that may never be built. So they're saying in order to decide the excess cost, Rocky Mountain Power, you have to go out and pay thousands, hundreds of thousands, whatever the amount is, dollars, and obtain an actual right-of-way, then come back to us, and the city will then use that information to decide whether we should go overhead or go underground. The problem with that is then the overhead right-of-way easements that we've acquired aren't necessarily going to be available for our underground line. I mean, the route could be different, the terms are different. So I think that to require a utility to actually go out and buy right-of-way easements is not, first of all, required by the statute, and in practice makes no sense.
I have one additional question for you. Counsel for Midway referred to the evidence received related to, and I think it's option one, that calls for 6,990 feet of cable and 5,300 feet of trenching, I think is the record, at least as I recall Mr. Myers' testimony. And he also, at least I concluded from his testimony, that it appeared that two of the three bidders had misinterpreted that, or at least their bid suggested that they were bidding on the basis of 6,990 feet of trenching. Do you know which of the contractors who bid on option one bid the intended specification of 5,300 feet of trenching?
So you're looking for the name of the contractor? Is that what you're asking?
Well, I'm a contractor A, B, or C, using the nomenclature from Mr. Myers' testimony, the chart in his direct testimony. That's what I'd like to know, is if it was contractor A, B, or C. If you know.
Yeah, we believe it's contractor A.
Thank you.
Yeah.
Hey, this is Thad.
Oh, this is Glenn Wright.
Oh, yeah, Mr. Wright, go ahead.
Yes, I have a follow-up question on Mr. Clark's initial inquiry to Rocky Mountain Power. Could you not go out and obtain agreements for easements without paying for them at this point?
Certainly you could go out and buy an option to purchase easement. That, I guess, is what your question is yeah, that would be an option for utility to go out and actually purchase options, which give you the right at some point in the future to purchase the easement.
Mhm. Well, I'm saying, could you not enter into an agreement with the landowners that if we need your easement, we will pay you this amount?
Well, I think there would need to be probably, I doubt a property owner would be willing to do that without some type of compensation. They would need some incentive to enter into that type of an agreement. So I think,
Okay.
To say if
All
they
right.
make it contingent, sure.
Yeah, I can live with that answer. Thank you.
Thank you, Mr. Wright. Any additional questions from board members? I'm not hearing any questions, so I think we'll move into board deliberation at this point. The council for parties are welcome to stay on the bridge line while we do this. We may have questions for them, although I'll just note this portion is deliberation, so we ask council or from the parties not to jump into the deliberation discussions unless we ask a question. And with that, I'll open it up to board members. Does any board member want to start the deliberation process or have any thoughts? I certainly have some of my own, but I'll open this discussion up to board members at this point. Please identify yourself when you begin speaking for the transcript.
All right, this is Glenn Wright. I'll start with some of my opinions, if we're ready. I look at this process as we have about 4 questions to answer. First is the need for this construction project and how immediate is the need, the construction costs, the right-of-way costs, and then the timing of the amount to be charged to Midway and Bolt, and the timing of that payment. In terms of the need, I agree with Rocky Mountain Power that this is a need. I base a lot of my argument, my opinion, on the public safety power shutoff program that was briefed to some Wasatch County elected officials last year, and testimony from both Mr. Norland and one of the Rocky Mountain engineers indicating that the Snyderville Cottonwood line would be vulnerable to this particular shutoff. Going through more than the number of wildfire seasons than necessary, I think, is a needless risk. In terms of costs, I think Rocky Mountain Power has absolute responsibility to set their own construction criteria. And from my past work as a safety engineer in the insurance industry, I fully support their conservative construction policies in terms of the trenching and the extra conductor that's connected. In terms of right-of-way costs, I am I think we're all aware that there's a lot of unknowns there. And I would suggest that we figure out what the actual cost of the right-of-way easements will be before we set a definite number to be paid. But I think we could set an initial number that is at the high end of the right-of-way costs and true that up. And by that I mean I would suggest Rocky Mountain Power immediately start getting agreements for the right-of-way, and that the commencement date of the construction would be when they have all of their easements. At that time, payment would be due. So that's my conclusions at this point.
This is Thad LeVar. Thank you, Mr. Wright. Any other board members want to interject any thoughts or comments? And I'm happy at this point to lay out my current thought process for where we are. As I look at the various issues in front of us, I think the need for the line isn't much in dispute, simply how quickly it has to be up and the time frame for it. Starting with the costs, I'll give my view as I've listened to the evidence on all the different sides. In my view, Rocky Mountain Power has made its case that its bids were conducted according to its standard procedures. I don't read anything in this statute that says this board needs to evaluate whether there's any potential way those bid specs could have been done in a less expensive way. At the Public Service Commission, we're often evaluating whether costs are just and reasonable. But in this case, all of the evidence points me to a finding that Rocky Mountain Power conducted these bids in accordance with its standard practices for this type of a project. And the fact that other expert witnesses proposed alternate ways that it could have been done doesn't take me anywhere away from that conclusion. With respect to the easements, the statute says that Rocky Mountain Power should provide, that this board is supposed to find the estimated value of any necessary rights of way. And an estimated value of right of way is never going to be an easy concept. I mean, trying to determine rights of way and easement values with any kind of specificity before they're ever negotiated and litigated if necessary is simply impossible. Rocky Mountain Power made an estimate based on its standard practices of estimates. We have some evidence that those estimates are low, some reasonable estimates, some reasonable evidence that those estimates might be low. However, the biggest problem with the evidence, particularly the witness provided by Midway City, is that witness used values of properties that don't actually have easements or takings involved with them. And in my view, those are completely irrelevant to the issue we have at hand here. Rights-of-way costs do not include severance damage, in my view, simply do not include severance damages to properties that don't have easements that go through them. So to me, that makes that counter evidence completely unreliable. And so on the easement issue, basically, my view is what we have Midway City and Volt asking us to do is they're asking us to increase the costs of Rocky Mountain Power's estimate for the overhead build, above line build, based on what they view as the delta between what easements would cost to build the ground above line and what easements would cost to build them underground. And I don't think we have enough evidence to clearly establish a delta on that. I think Midway City recognized this when they drafted the CUP in a way that requires for a true-up of actual easement costs. I don't think it's reasonable for this board, and I don't think it's required by the statute when it says estimate necessary rights-of-way to determine a dollar value of this is the difference between what easements would cost for an above-ground line versus a below-ground line. I think that's what we're being asked to do by some parties. I don't think it's reasonable, and I don't think it's required by the statute. And I think we have a reasonable easement number that will be trued up pursuant to the CUP. So I'm comfortable with that. My feeling is that Rocky Mountain Power's estimate of the above ground cost was done also according with its standard practice to estimate those costs based on a self-build option that it had done in a similar process previously. To me, is reasonable evidence of the self-build cost. The bids are reasonable evidence of the underground cost. In Public Service Commission proceedings, we evaluate bids on a regular basis, and I'm not aware of any instance where bidders have been required to provide testimony on how they developed their bids. The fact that the bids were received speaks for itself on the bids, and they're established simply to show that the bids were sent, not necessarily the truthfulness or the process that went behind those bids. And finally, my thoughts with respect to a commencement date. I think Rocky Mountain Power's testimony that it can't be completed in 2020 leads me to where I would probably be in favor of a finding that the March 1st date proposed by Midway City for construction commencement probably isn't that far off from when Rocky Mountain Power actually could get this line going. I think giving Midway City a chance to have a bond election probably seems reasonable. So all that being said, where I'm leaning right now would be an order that would give Midway City 15 days from the date of the order to choose the route pursuant to the CUP, and then establish a March 1st commencement date. 30 days before that is when Midway City would be required to provide payment to Rocky Mountain Power. So those are my thoughts at this point. I'm not saying I couldn't be convinced otherwise if other board members have different views or different perspectives on it.
Chair LaBarre, this is Troy Fitzgerald. Could you just clarify your last couple of statements there about your dates? I was confused about the March thinking.
Well, my view is if we issue an order saying that we're affirming Rocky Mountain Power's costs based on the bids, I think we should re-trigger Midway's right to have 15 days under the CUP to choose its preferred route. But then the second deadline is they're required to pay the excess costs 30 days before the construction commencement date. So we would need to set a construction commencement date. Midway City has suggested March 1st that would give them a chance to bond, to put a bond on the election ballot in November. obviously Rocky Mountain Power opposes waiting that long. To me, the testimony of when this line could be completed reasonably leads me to think the March 1st construction commencement date is probably reasonable considering the risk in the area. There's some risk of outages if it's delayed to that point, but the risk has existed for some time. And as we look at, I'm trying to remember the statutory phrase. I had it in front of me during the closing statement, but I don't have it in front of me. Oh, here it is. The Midway City, if we determine that the cost, make a determination on the cost, Midway City is required under 54-14-204 within 30 days before the date construction of the facility should commence in order to avoid a significant risk of impairment to the safe, reliable, and adequate service to customers of the public utility. Under that standard, I think we have evidence on the risk of impairment to safe, reliable, and adequate service. To me, the March 1st date proposed by Midway City reasonably addresses that risk of impairment to safe, reliable, and adequate service to customers of the public utility. And considering their desire to seek a bond from voters of Midway City, I'm not opposed to that. But I do think if we issue an order, Midway City's obligation to choose a preferred route from the bids should run 15 days from the date of the order. Does that answer your question, Mr. Fitzgerald, at least on my thought process?
This is Troy Fitzgerald. Yes, that's helpful, but again, for clarity, that's March 1st, 2021, correct?
Oh, I'm sorry. Yes, I did. Yes, that's what I meant, 2021.
This is Troy Fitzgerald again. I think your answer made that clear, and my confusion came because of the March 1st, 2020 date found in the conditional use permit. I guess since I'm speaking, maybe I'll toss my thoughts out. Similar to, in some ways, different in others. I think the need for the project has been established, and through the closing arguments, my mind was taken more to the conditional use permit issued by the city. The city laid out its requirements with great specificity. Rocky Mountain Power's obligation was to provide bids. They did that. The date in the conditional use permit that those should have been submitted was February 15th. The evidence indicates they didn't come in until March 27th. So for me, I don't have any problem extending the dates as stated in the conditional use permit. I think that's about 41 days. In fact, the conditional use permit says if Rocky Mountain Power is late on their submission, that the timeline should all be delayed. To me, that indicates that Midway City would have until May 7th to complete their portions of the CUP requirements. Otherwise, in accordance again with the conditional use permit, if they Midway City have not completed their requirements, then the line becomes an overhead line. To me, with regard to the easement costs, I think the proposal of Mr. LeVar is not a bad one. I agree that we can't determine the actual costs of the easements. There is testimony out there that there's significant overlap in the estimated cost of easements for overhead and underground. So I think it's reasonable to conclude that the standard cost and the excess cost would be increased by a similar or like amount, meaning the difference between the two would be the same regardless of the end cost of those. So I'd suggest that as a conclusion to this. I think there's some evidence that the underground easements would be cheaper, and if we wanted to allow for that in some fashion, I think we could. So those are my thoughts right now.
This is Jordan White. Can I, Chair LeVar, ask your permission to ask Mr. Reich a question? I just want to follow up on some of the thoughts of Mr. Fitzgerald with regards to Rocky Mountain Power complying with their obligations to provide the bid in a timely fashion with a conditional use permit.
Mr. Reich, are you still on the line?
Yes.
Okay, go ahead, Mr.
Yes.
White.
Can you hear me?
Yes, I'm still on the line.
Yes. Oh, sorry. I thought you said Mr. White. You were saying Mr. Reich. Yeah. My question, I guess, I just was hoping you could respond. I wasn't aware there, or it wasn't my understanding that the Rocky Mountain Power essentially missed the deadlines to provide the qualified bids under the conditional use permit. Is that? Can you help me understand that or clarify that?
Yes, and I agree in the conditional use permit, it says if the bids are not submitted by that date, there's a day-for-day slip. I guess where my disagreement comes, I don't think it's May 7th, I think it's April 10th is the day-for-day slip. So I think the deadline then changed to April 10th for Midway City to then pick a route.
Yeah, that was my understanding as well. I'm happy to, unless.
Oh, sorry. I think that's a reasonable interpretation as well, that they would have 2 weeks after the submission time.
This is Saddlebar. Who was that just spoke?
This is Troy Fitzgerald again.
Okay, thank you.
And this is Jordan White, I guess, along the lines of what Mr. Fitzgerald said in terms of I already speaking, I guess I'll get to my initial thoughts too. First of all, I just want to say, I agree, Midway is a gorgeous city, and I understand that people don't like power lines, but I also, that reliable electric service is an integral part of, the fabric of modern life. And the testimony we've heard over the past couple of days and presented on in terms of the, pre-filed written testimony is undisputed. There's a clear need for the project to provide safe, reliable power. And I recognize there's been discussion about the continuing probabilities with respect to risk and reliability of whether it will not occur, in that type of prognostication, I guess. But the fact is that every day without the project presents a risk to customers. In reading through the history of the case and the development, it appears that, Rocky Mountain Power has worked with the city over the past several years, I guess, since 2017, as far as I can see, in terms of the initial project development. And they ultimately did receive a conditional use permit in 2019. When I look at that conditional use permit, it seems pretty clear that, and I'm just going to pull up the conditional use permit here, just so I can make sure I'm reading it clearly, I guess. But under that conditional use permit, there's a phrase in there where I guess that some verbiage that essentially says, scroll down on the computer, but if the applicant has met all of the city's requests given in this motion in time and manner, but the city has not been able to secure all of the items, and I won't go through all those, but you can read it yourself on page 4 of the fish use permit, that by March 1st, 2020, then the applicant may proceed with the overhead construction with the following conditions, and it goes on to include conditions. And I recognize that date is flipped to the extent that there's a day-for-day change to that, but I go to that plain reading, and with respect to the again, the need has been established. They provided qualified bids under their specifications. I recognize, after hearing the testimony of Mr. Nelson, that there are differing specifications or internal engineering specs for building transmission lines. But I've heard nothing to suggest that Rocky Mountain Power was in any way doing anything untoward or incorrect in terms of their specifications. It's just their specifications. In terms of the right-of-way costs, again, I recognize. I think that's a good point, made by Mr. Wright, that potentially they could secure options, but I don't know how they would ever be able to come up with an actual cost because there's so many variables that go into it. They can only estimate at this point without either litigating it or actually having a signed contract, et cetera. So I just don't know how they'd ever achieve that. I guess ultimately, I'm willing to kind of, I'm intrigued to some extent by this concept of looking at a potential ability to pass the bond, but that gives me concern. Again, we're already, from the evidence I've heard thus far, there's been a need for some time. That need doesn't go away. Every day that project does not proceed it pushes that day further beyond. And so I understand that elections and bonds, elections especially, there's no guarantees. I guess I'm a bit concerned about kicking that can down the road for yet another year. So I guess what I would say, I'm cutting the chase there. That if I were to vote right now, I would vote to allow Rocky Mountain Power to proceed with immediate construction of the overhead design for the reason that they have satisfied the conditions under the conditional use permit, and that permit is express. So that's kind of where I'm at right now. Is that again, I recognize they're not popular. It's a beautiful area. But it's such an important part of the need for reliable electric service in society is so great that is ultimately, that's why I believe the statute is written the way it was, is to ultimately the buck's got to stop somewhere in terms of having to build a power line to maintain reliability. And I think this is the obligation of the board. So I'll stop talking there for a while and let another board member speak.
And this is, thank you, Mr. White. This is Thad LeVar. I'd like to just interject one thought to what you've said. The one issue I'm struggling with what you've proposed is if we strictly hold to the deadlines of the CUP and rule that, okay, Midway didn't choose an option within 15 days of receiving the bids, therefore Rocky Mountain Power may go forward on the overhead lines, are we basically making Midway City's right to come to this board to dispute those bids and dispute those costs, which they have a right to do, but are we rendering that right meaningless? Because if we say, well, we're sticking to the deadlines of the CUP, that doesn't give Midway any opportunity to come to this board to make their arguments that the costs weren't estimated actual reasonable costs. That's my concern with that direction. But if you have any thoughts on that, Mr. White, or other board members, I'd be happy to hear them.
This is Jordan White. That's a very fair point. I guess part of my rationale behind that, frankly, is the fact that I saw the Discover responses with respect to the bid submissions and the note from Rocky Mountains Power Council with a no reply to that. No question of a request or criticism or otherwise of those bids. And that, I guess that partially informs my decision. But I guess the short answer to your question is yes. I think that at a certain point, if a party goes before a public body like a city council, and essentially the conditional use permit amounts to essentially a contract between the petitioner and the city, and one party upholds their obligations and the other party doesn't, I'm not sure where that leaves you. So I guess ultimately what I'm saying is yes, the city has waived their rights under that conditional use permit.
This is Troy Fitzgerald. I'd suggest that they'd be given the amount of time they bargained for in the CUP that they drafted, give them a couple of weeks to finish and or make their solutions known under the CUP, and if they can move forward, they can. Then the board will have established what the excess costs are. They'll have resolved that dispute and the actual costs. So the board has done what it's done, and then Midway City can make its decisions. I would note that in their conditional use permit, there was zero mention of a bond election. The city has a number of funding mechanisms available to it that don't require a general obligation bond. They can use any of those, including the one that they suggested directly in the conditional use permit, which is going to Heber Light and Power.
But just to clarify, this is Jordan White, Mr. Fitzgerald. So just so I understand the timing of what you're suggesting, it sounds like it's a bit of a tweak on what Mr. LeVar was suggesting. You're suggesting that, help me understand a little bit more about what that would look like.
Sure. This is Troy Fitzgerald again. That I would just say that they would have, I can't remember if it's 14 or 15 days, but 14 or 15 days from the issuance of the written order for Midway City to complete what they've done or what they need to do under the conditional use permit. If they're unable to then secure the three things they've indicated they need to do in the conditional use permit, then the overhead line could begin moving forward at that time, 2 weeks after the issuance of the written order from this board.
This is Jordan White. That seems fair to me.
This is Thad LeVar. I'd like to ask Mr. Fitzgerald for a little bit of more clarification on your proposal. The CUP requires Midway City to choose a route within 15 days, and I agree we could set that based on our order. I think we still need to set a construction commencement date for safety and reliability that would trigger 30 days in advance of that date Midway City's obligation to actually pay those costs. So, does your view of the CUP give us a path to setting that date in a way that once they choose the route within 15 days after our order, they also have a deadline to pay those costs 30 days before a construction commencement date?
Well, maybe we're crossing a few things. Again, this is Troy Fitzgerald. In the conditional use permit, as I see it, Rocky Mountain was to submit their bids by February 15th. And then by March 1st, 2020, the applicant may proceed with overhead construction with the following conditions, unless Midway City had been able to secure, again, the CUP language, 3 items, which was sufficient funding to pay and a minimum and donation fund dollars and Wasatch County Council approval of something. To me, they set their own deadline on when that would be. I don't remember seeing anything else in there about when the payment would actually be made. So I guess I'm just looking to honor the permit that was issued, saying they would have that period of time between 15 February and March 1, however many days that is, to do those things, which I assume included payment, although I don't know that that's clear.
And this is Thad LeVar. I'm in complete agreement that our order should clarify that within 15 days out of the order, all of those CUP obligations should be satisfied. To me, the obligation to pay, which I think isn't clarified in the CUP, comes from statute, and it's the Facility Review Board Act that says the payment has to be made 30 days before commencement of construction. So, the CUP requires the funding to be secured within 15 days. So then when would we need, but I think this board probably still needs to give a date for construction commencement for safety and reliability that would trigger that statutory obligation of payment.
This is Glenn Wright. I have a suggestion on that. I suggest that at the same time Midway picks a route and the cost of that route, they also get a commitment from the board of Heber Light and Power, where they have a board seat for the necessary funding, probably through a revenue anticipation bond for ratepayers in Midway. And in terms of the payment date, I think we can be a little flexible and figure and get some feedback on how long it would take to execute that bond. And if for any reason the bond was not executed within a date that we can set, then overhead construction starts.
This is Thad LeVar. I'm sorry to keep interjecting, but that makes sense to me. And I just wanted to point out one light that just came on to me from when Mr. Fitzgerald was reading the CUP commitments. Since the CUP requires the funding to be secured within 15 days, I think that precludes our option of delaying this for a November bond vote. I think that I hadn't made that connection before I made the suggestion, but I think I agree that the CUP text itself doesn't allow us to say they're not going to secure the funding until November. So I think I no longer support that option based on the language of the CUP.
This is Troy Fitzgerald. I'm okay giving a reasonable time to secure that funding as well. If we triggered it 2 weeks after for choosing a route from the date of our written order, and then 60, 90, 120 days, whatever seems reasonable for bonding discussions to happen, then you would have all the dates necessary that the parties on both sides could rely upon.
This is Jordan White. And I'll probably rely on Mr. Fitzgerald just because this is his area of practice. But and maybe with Mr. Wright, you mentioned other sources of funding. I'm assuming that the question of whether or not they could get an election, completed in November for a 15-day time period is a moot question. But what other options would be? Obviously that's not necessarily with our purview, but what are some potential options other than seeking a bond through an election in November within the 2 weeks for a municipality?
This is Troy Fitzgerald. I don't know Midway's circumstances or financial situation enough to really comment on that. There are bonding options that simply require the city council action and not a general election. I think I fully understand why they're interested in that, because of what revenue sources they would like to use to pay that money back. I would just say the only evidence we have in front of us right now is that the city council considered that and passed a conditional use permit indicating what their funding source would be, and it was not a general election. And even in the evidence that came before us now, I think we have indications that that's Midway's desire at this point, but we don't, the council could have passed the necessary language indicating they're moving forward with an election this fall. There's no evidence of that. There's no evidence of anything other than oral statements of council that that's their intent, at least that I can recall.
This is Jordan White. Thank you. That's very helpful.
This is Glenn Wright. I think if I remember some of the discussions during the CUP discussion, that Hebrew Light and Power was a possible source for funding, through a rate-based bond for the ratepayers in Midway. But at any rate, I agree with Mr. Fitzgerald that Midway needs to come up with the solution in the next 2 weeks.
This is Dave Clark. Let me present some of my thinking now as well, since I'm the only one who hasn't yet. I would not favor a conclusion that the Midway City has forfeited its right to pursue underground construction Yet I do conclude that the need for the facility exists. I see it as a continuum of pressure that's been building and will continue to build, and at some point becomes untenable. Are reaching conclusions that would accommodate a construction beginning in the spring of 2021 seemed reasonable to me, so I was attracted to and found my thinking to be consistent with what Chair LeVar expressed regarding a March 1st construction date commencement. I think we need, whatever we do needs to provide some assurance that Rocky Mountain Power will have the certainty of outcome that it needs to begin to build by that time. Regarding the standard, the specifications and construction standards evidence, I feel strongly that our role should not be to re-examine the existing standards, and I feel there's been adequate evidence ample evidence really, that Rocky Mountain Power pursued its standard processes in both the design and the bidding of the underground project. And I think the evidence of the bid information is also adequate for us, and I wouldn't contemplate us ever requiring that the bidders actually present the information that underlies their bids to us. So I feel we've got adequate evidence on the bids, adequate evidence of what the actual costs will be. Regarding the standard costs, one thing I'm considering is adding to the costs of overhead construction the $691,344 that to me is somewhat convincing evidence of what the right-of-way costs are likely to be. And that number comes from both Witness Weber and Witness Lefevre, and it's particularly specified in Witness Lefevre's rebuttal testimony. And so that would be one thing that I ask my fellow board members to consider as we determine what the excess costs will be that we find in this matter. So those are my thoughts at this stage.
Thank you, Mr. Clark. This is Thad LeVar. I'd like to ask you just one clarification question, if you don't mind. Is that okay with you?
Yeah, sure.
So does your final statement on easement values, and I know where you're getting that number from, are you saying that you're convinced and ready to make a finding that easement cost would not apply to the underground project? We have some verbal representations of donations of easements. Is that evidence sufficient to you to say we think that cost should apply to the overhead project but not to the underground project?
Well, I guess that's the question I'm raising. I'd be inclined to make that judgment for the purpose of determining what the excess cost is to accord that representation that's been made to us, the benefit of the doubt, for lack of a better phrase.
This is Glenn Wright. Go ahead.
Yeah, no, go ahead, Mr. Wright, go ahead.
Yeah, I think I agree with that analysis. And in any case, if they go underground and incur additional right-of-way costs, that would be in the true-up.
Thank you, that's the point that I was going to make the same point, Mr. Wright, so thank you. The true-up does give us some wiggle room on easement values.
Right, so that's why I feel like in fairness, I would give the benefit of the representations that have been made to us, to the city at the outset, at least.
And this is Saddlebar. We're using the six. Oh, go ahead, Mr. Clark. I mean, Mr. White.
No, I wasn't saying that. Oh, I apologize. Just a question for clarification. So you're suggesting that we would if we gave them the benefit of the doubt, that you would reduce the delta between the actual and excess cost by the $600,000. In other words, the ultimate, whether it's through however they receive the funding, it would just be reduced by that amount and then it would be trued up at a later time. Is that what you're suggesting? Is the $600,000 plus?
Right. That's. I'm assuming that the true-up would allow any final adjustments up or down to be made. But I would give the benefit of the evidence that we've received on from Mr. Weber with respect only to the properties that are actually impacted physically by the construction. I think there are 9. And so I would give that benefit in our initial assessment of excess cost to the city. Well, I'm suggesting that we consider that at least.
And this is Saddlebar. You're suggesting the $691,000 number?
Correct. There are 2 numbers.
And that's Mr. Clark speaking, correct?
Yes, thank you.
Okay, thank you.
Yeah, thank you. Thank you. This is Dave Clark. There are 2 numbers in Mr. Lefever's testimony, and I think we received evidence that one of the properties was duplicated in the analysis, and so I'm the number of 691,344 is the one that I think is most applicable.
Well, this is Thad LeVar. It seems like we're approaching board consensus on most issues. It's not clear yet if we have board consensus on that easement issue. Mr. Wright kind of indicated some thoughts on that, and I think I would not have any opposition to including that in our order, that estimate of right-of-way costs. But are there any thoughts from other board members on that easement issue or where our discussion has been generally?
And this is Dave Clark. Could I just add one other thing? I also wanted to express on this question of easements that I do not think that the statute requires, nor would there be any reasonable way for us to require Rocky Mountain Power to present the actual cost or to identify the actual cost of the rights of way at this juncture. And so I simply wanted to state that for the record.
And this is Jordan White. With respect to Chair LeVar's question, in light of the fact that there's a true-up option, I don't have an issue with the easement adjustment that's suggested by Mr. Clark.
This is Troy Fitzgerald. I have a similar thought process there. I'd be fine including that.
Okay, well, this is Thad LeVar. I think we're approaching a board consensus. I'm not entirely clear we have a consensus on a construction date that would trigger the payment 30 days in advance. The discussion of the CUP language has led me to believe I don't think that is as crucial as we thought, since the CUP, if the CUP requirements are not met within, I think as we're discussing, 15 days after the issuance of our order, Rocky Mountain Power would have the right to move ahead with building the line above ground. But in the event that the CUP conditions are all met within 15 days after our order, I think we still need to set what's the construction commencement date that would trigger the payment requirement under the statute 30 days in advance of that date. So we've had some discussion of March 1st and some discussion of whether that should be sooner. Do any board members want to bore down on that issue any further?
Mr. LeVar, this is Jordan White. So just to be clear, are you suggesting, because maybe this is that date would be March 1st of 2021? I'm assuming that's what you had in mind. In other words, so the city would have to provide. Help me understand that. My real question is, under what you're suggesting, when would the construction commence of the project?
Well, if we were to use a March 1st, 2021 number, that would be the construction commencement number date, and Midway City would be required to pay the excess cost to Rocky Mountain Power 30 days before that date. Now, I think this issue is less significant than I was originally thinking, because I was not remembering that the CUP required funding to be secured. So if the CUP requires the funding to be secured within 15 days after the costs are presented, which we're going to be doing in our order, on one hand, I don't think the construction commencement date is as crucial. On the other hand, I'm not sure a March 1st, 2021 date prejudices much, because Midway City is still going to have to secure the funding. So maybe it doesn't make sense, because I don't know if a bond election is even possible, considering that CUP language that says the funding has to be secured. So I guess I'm saying, I don't know. I'm not sure I know what I want to do with this construction commencement date. I'm in a cloud on it.
Well, this is Jordan White, and let me just. I'm speaking a little, and I'm thinking out loud here for a second. So essentially, what we're talking about, or what we're proposing, we're kind of circling around the potential motion here, is that we would allow the city to secure funding, by a date certain, say, 15 days from the date of issuance of the order, et cetera. But your question is, in conjunction with that, do we need to set a date for commencement of construction? I don't know if potentially we could provide a no later date than it was somewhere around after that 2 weeks date. Well, hold on. Let me just think here for a second, because if they were to secure the funding, what would that mean? So it's almost like we need a condition subsequent based upon. There's two different routes here. If the funding is not secured by the 15 days after the order is issued, the construction date will be, the commencement date will be that date, the date of the failure of the conditions. If they do secure the funding, that's the question I think we need to focus on. If they were to within the 15 days of issuance of the order, secure the funding, what do we need to provide a date for commencement of construction under that scenario?
And this is Thad LeVar. I agree with that, and I think Mr. Fitzgerald, near the end of the discussion of this issue earlier on deliberation, suggested 60, 90, or 120 days after that 15-day expiration period. Am I remembering your suggestion correctly, Mr. Fitzgerald?
This is Troy Fitzgerald. Again, looking at the conditional use permit, Midway would be seeking Heber Light and Power board approving issuance of bonds, I think they would need time to do that, and that's going to take, I think, a minimum of 90 days. You're suggesting from the statute that they need to tender that payment 30 days before the commencement date. So if we were to give them reasonable opportunity to complete what they were anticipating back in December, I do think they would need a minimum of 120 days from the date, the commencement date you're calling it, so that they could tender 30 days before that. That's an extremely tight timeline, though, for obtaining bond funding in any circumstance. And I think we heard from council saying the same thing. If you pass a bond election in November, to get the actual funding by January or February is very, very tight. And we're in very interesting times where I would say the bond markets are not functioning at top speed. So with all of that out loud thinking, maybe what I would suggest is 180 days for the commencement time from now. And we could pick that date, but that should give the parties enough time to do everything they've contemplated in here of actually tendering the money. But Rocky Mountain Power could proceed in 15 days knowing which direction that's happening, and Midway would have their opportunity to determine which direction they want to go as well.
Thank you, Mr. Fitzgerald. This is Thad LeVar. Listening to your reasoning, I'm comfortable with 180 days. Were you suggesting 180 days from the date of the order, or 180 days from the expiration of the 15 days after the order? I'm fine with either.
To keep it consistent, I'd say 15 days after the date of the written order.
And then 180 days after that?
Correct.
I could support that.
This is Jordan White. I could support that too. I ultimately, just to piggyback on what Mr. Fitzgerald said, I think ultimately having some certainty was probably what's critical at this point, whether it's underground or above ground, just knowing something in a reasonable manner. So I would support that.
This is Glenn Wright. I support that also.
Dave Clark, I agree.
Well, this is Thad LeVar. Let me ask the board this: do we have enough clarity of discussion that we could pass a motion asking the Public Service Commission staff to draft an order consistent with this discussion, or do we need to outline our decisions a little more specifically to direct that order drafting?
This is Brett
I'm
Rack.
sure if our attorney were on the line, he would beg us to give a little more specificity to our motions.
One clarification from Rocky Mountain Power. Do you mean by commencement of construction actually shovels in the ground, or are we talking about securing right-of-way and engineering as defined in the statute?
This is Thad LeVar. I think we would be using the term as is defined in the statute, and we would not be defining it any further, but giving a date attached to that statutory term.
Then the concern of Rocky Mountain Power is if the money's not tendered for 180 days, we cannot start engineering, we cannot start ordering materials or obtaining right-of-way until the money's tendered.
Right, and the statute requires the money to be tendered 30 days before that construction commencement date. I think that's also a statutory issue that we can't modify.
Mr. LeVar, this is Mr. Morris. I had a question on the true-up.
I guess we're starting to entertain questions from parties, although I don't want to turn this back into more closing statements. So I think the board is close to making a motion and coming to a decision and directing an order. But if there are some limited questions from parties, since we've already had some from Rocky Mountain Power, we need to continue allowing it. But there needs to be some reasonable limit on how far we go there. So, Mr. Morris, go ahead.
please let me know if I go too far. I mean, it's just a simple question. It seems that the board is inclined to proceed with an understanding that there will be a true-up at some point, and I just want to make sure I understand that the true-up would benefit either party. It could go up or down, and that, for example, if the easement costs of going overhead turn out to be more than what the board believes they are today, that would correspondingly reduce the amount of money Midway would ultimately be responsible to pay to go underground. Was that clear?
Well, this is Thad LeVar. I think as a practical matter, if the line is ultimately constructed overhead, then Midway is not paying anything to Rocky Mountain Power, and all of that becomes moot. I think our board discussion is that we're going to make, as we determine what we consider the cost of $691,344 difference between, that's the amount we're estimating the easements for the overhead line would cost. We're assuming we're giving the benefit of the doubt that those easement costs are not going to be imposed on the undergrounding of the line. And if it's undergrounded and if Midway pays for the undergrounding, then there's a true up if that assumption becomes incorrect as the process moves forward. But going the other direction, if it's overhead, personally, I don't see how the true up applies, because in that scenario, Midway is not paying Rocky Mountain Power anything.
No, that's exactly my understanding. I'm not concerned about going overhead. That'll just roll out the way it will. But if it goes underground, and if the board determines that preliminarily, at least, that there's a $691,000 delta on actual cost, but in other words, would Midway have an opportunity to show that the board came in light on that and show that if it had gone overhead, the cost would have been X, and if it were more than the $691, would that allow for a reduction in the amount that Midway ultimately has to pay?
And you're asking the board a question. I'm happy to let any other board members weigh in. I think the board certainly would have the ability to hear any disputes between the parties if it proceeded to that point and there was a dispute over the easement values. That issue could be brought to the board if it's not able to be resolved between the parties. But I'm not sure we would, in our order at this point, anticipate any of that dispute resolution down the road. But if other board members see it differently, please weigh in.
Well, this is Jordan White, and maybe I misunderstood the question, but I guess to me it's just as simple as that he would reduce the estimated excess cost or whatever. In other words, the delta. So I guess I'm just kind of trying to wrap my head around, Mr. Morris, when you're looking for this to be resolved. To me, it's just the amount of money would have to be raised. Ultimately, if it was off, that's when it would be trued up down the road when the final construction and cost, et cetera. I guess I'm just trying to understand what you're suggesting at this point, how that would look.
So what I would be interested in seeing in the order is an opportunity for Midway down the road to show that $691 was not enough of a delta to offset the difference between the two numbers. And as long as the order doesn't preclude Midway from having that opportunity, I guess I don't mind. And Rocky Mountain would have a corresponding right, I suppose, to suggest that it shouldn't have been that much, the $691. But I mean, fair is fair. But I just would hope that a true-up would be available to both parties to move the number up or down, depending on what that ultimate easement number should be.
This Brett Reich with Rocky Mountain Power, if I can respond to that. The $691,344 is the estimated standard cost for the right-of-way on the overhead line, is what I think the board discussion has been. And the discussion was to fix that cost at $691,344 as the estimated standard cost of the overhead line. I think there's a little bit of confusion about the true-up. The true-up would only come into play if the line goes below ground. And even if there were a true-up, that $691,000 would never be trued up. I mean, you're saying that's going to be a fixed cost. You're accepting that as the estimated cost of right-of-way. So that number is going to go into the construction cost of $1.8 million for a combined of $2.5 million. That's going to be the estimated standard cost of building the project overhead. So if we go ahead and go to the underground line, if Midway City raises the money, if they get approval from Wasatch County, and they pay the money in whatever time frame the board submits, then the true-up provision would be on the amount that they pay and the amount that project actually ends up. And that fixed right-of-way cost of $691,344 would be set. It wouldn't be subject to any kind of alteration. I think at least that's what I heard the board say, and that's what I thought that they intended.
And this is Mr. Morris, and my concern about that is I'd be concerned that this board would fix an estimate. I mean, the board could just as easily fix it at $27,000 or $8 million. But it ought to be subject to a true up at some point, and not that an estimate not be fixed today. That would be my request.
Okay, thank you. I think we've heard the parties' positions on this. It doesn't take me very far from where I was, and I think I can't see it any differently from the way Mr. Wright described. If we set the standard cost, including that $691,000, and then if the line is built underground, if it's undergrounded, then we would true up the actual easement cost. But if it's built underground, I can't envision any scenario where the estimate of what it would have cost to get easements above ground could ever be in dispute at that point. I mean, I think that's a hypothetical that I can't imagine. You know, if the line's built underground, there will never be actual evidence of what the easements would have been to build it above ground. So I think we're talking in impossible hypotheticals, at least in my view. But let's come back to the board. Are we ready for a board motion?
Well, this is Dave Clark. Let me just say that I did not intend the identification of the right-of-way component of actual cost to be fluid. I intended it to be fixed, and the way you've described Chair LeVar and Mr. Wright, the true up to work is what I envisioned in my proposal.
Thank you, Mr. Clark. That's helpful. If any board members see that differently, please speak up.
Commissioner LeVar, this is Corbin. Just one short clarification. Is there going to be a surcharge included in the above ground costs?
We have not had any board member advocate for that at this point. I'll state to the board, my view is that the surcharge was established by evidence that that's Rocky Mountain Power's costs for managing their bid process and bidding it out. And I think we have evidence from their witness that those costs don't apply to a self-build above ground. That's my view. If any other board members see it differently, that's also an appropriate item for discussion.
Yeah, this is Jordan White. I'm just assuming, again, maybe I'm mistaken here, but the overhead costs are part of whatever construction costs, the Rocky Mountain Power, that's the standard, part of the standard construction costs. So I guess I just don't understand if you're wondering whether we're going to extract that from I don't, that doesn't make sense to me. There will be an overhead cost as part of the construction cost, but maybe I'm misunderstanding that question.
Well, Mr. White, maybe I can clarify. I think Mr. Gordon was asking about, there was I think it was in the neighborhood of 275-ish, I don't have the dollar in front of me, surcharge that Rocky Mountain Power was putting on the cost of the bids, adding on to the bids for their cost of managing the bids, and they did not include a similar cost in the standard cost for the overhead line that they would not be bidding at but would be doing themselves. Is that, Mr. Gordon, am I referring to the same thing you're referring to?
Yes, and my understanding was they would still have those costs if they were going above ground. So I'm just asking if that's something that the board wants to consider including in the above ground costs.
Mr. White, does that clarify anything for you?
Yeah, thanks for the clarification, Mike. So yeah, I stand by where your position was, Chair Lamar.
Any further board discussion of that issue? Any other board discussion generally, or a motion from any board member? I'll go ahead and make a motion that the board direct the staff of the Public Service Commission to draft an order to be issued no later than May 8th, consistent with the board discussion today. Any discussion or second to that motion?
Right, second.
Okay, sorry, we had Mr. Clark and Mr. Wright speaking at the same time. Why don't we go to Mr. Wright first?
I will second that. This is Glenn Wright.
Okay, thank you. Mr. Clark?
I vote yes.
Okay, any further discussion before we continue with voting on the motion? I'm not hearing any discussion, so Mr. Clark voted yes. Mr. Fitzgerald?
I vote yes.
I vote yes. This is Thad LeVar. Mr. White?
I vote yes.
Okay, thank you. Mr. Wright?
Yes.
Okay, do any board members have any issues that we need to address before we adjourn? I'm not hearing any. I just want to say to all participants, thank you for your participation in this difficult hearing. The issues weren't simple, and the circumstances of doing this telephonically gave all of us some challenges. I appreciate everyone's help in doing this. I think everyone has been as accommodating to the realities that we were facing with the timing of this hearing. Thank you for everyone in the participation. I want to thank you to the court reporter who was very helpful and the Public Service Commission staff who made sure that we got this streamed and available to the public. And thank you to the board members, particularly those who are not associated with the Public Service Commission, who are donating your time from very busy lives to do this. With that, we're adjourned.
Thank you.